Picture this. A bank forecloses on a rental property. Most tenants instantly assume they have, maybe, 30 days, max, to pack up their entire lives and get out. Well, that assumption is a massive, multi-billion-dollar fallacy. Under federal law, a bank foreclosure on a rental property absolutely does not equate to an immediate eviction notice for the tenant. In fact, many tenants possess the ironclad legal right to remain in their homes for months or even years after their landlord loses the property to the bank. In this explainer, we're going to break down the precise statutory shields available to protect tenant stability, and we'll expose the foreclosure fallacy for what it really is.
Just look at this. Search interest in foreclosure-related tenant rights has skyrocketed an incredible 750% in recent months. That's a staggering statistic, and it really signals a massive gap between the actual law and public awareness. Foreclosure naturally creates a chaotic environment for housing providers, and, as you'd expect, severe panic for the renters living inside those properties. However, federal law provides a firm baseline of stability for the occupants. It was designed specifically to prevent a massive wave of immediate, unwarranted displacements.
Quick disclaimer up front, this analysis is strictly for educational purposes and does not constitute formal legal advice. All right, the federal shield against immediate removals breaks down into 5 key parts. 1. The federal shield. 2. Bona fide requirements. 3. State upgrades. 4. Security deposits. And 5. Strategic defense.
Let's jump right into Part 1, the federal shield.
We really need to shatter this widespread misconception right out of the gate. Does a bank notice automatically equal an eviction notice? The answer is an unequivocal, resounding no. A bank simply lacks the unilateral authority to mandate an immediate vacancy just because the property changed hands in a foreclosure sale. The legal framework surrounding tenant rights heavily restricts this exact kind of abrupt displacement.
The core protection here is the Protecting Tenants at Foreclosure Act, or PTFA for short. This federal statute dictates that the new owner, which, let's face it, is usually a bank, takes the property subject to existing tenancies. In legal terms, the lease actually survives the foreclosure sale, and the bank essentially steps right into the shoes of the former landlord.
Under the PTFA, the exact protections vary based on the specific rental agreement. For occupants with a valid, fixed-term lease, the law guarantees their right to remain in the unit and pay the normal rent amount until the very last day of that lease. And no, the bank cannot just arbitrarily shorten this term. Even for folks operating on a month-to-month agreement without a long-term contract, the law mandates a minimum of 90 days written notice before a bank can even begin an eviction filing.
Moving on to Part 2, bona fide requirements. Now, it's important to note that not every occupant automatically qualifies. To activate this shield, the tenancy has to be legally classified as bona fide. The law identifies 3 mandatory criteria to check off. Step 1 requires the lease to be an arm's-length transaction, meaning it's a standard, legitimate business agreement. Step 2 demands that the rent must not be substantially below fair market value. And finally, Step 3 dictates that the tenant cannot be the mortgager or the landlord's child or immediate family. This prevents property owners from drawing up fake, deeply discounted leases with relatives just to block a bank takeover.
Actually, scratch that. One quick caveat: subsidized housing exceptions do apply to the fair market rent rule for those on government assistance. However, the crucial point is that if these core conditions are met, the lease serves as an absolute ironclad defense. It is legally binding on the bank, regardless of the foreclosure outcome. That means the financial institution is stuck with the tenancy until the statutory or contractual period fully expires.
Which brings us to Part 3, state upgrades.
So the PTFA is really just the baseline, but local laws can vastly enhance those federal statutes. In jurisdictions like California and New York, local just cause ordinances prevent a bank from evicting a tenant even after the 90-day federal window expires. Under these state-level upgrades, the expiration of a lease or a change in ownership is simply not enough to force a removal. The bank literally must point to a specific lease violation to proceed. As you can imagine, this severely limits unilateral bank power. In these just cause areas, banks must prove a legitimate at-fault reason for the removal. We're talking things like non-payment of rent or severe property damage. A bank cannot remove a tenant simply because the institution wishes to sell the property vacant on the open market.
Let's pivot to Part 4, security deposits.
Here's a huge point of contention. When a property goes into foreclosure, the security deposit does not just magically disappear into thin air. Legally, the original former landlord is required to either transfer those funds directly to the new owner, the bank, or refund them directly to the tenant.
More importantly, under state laws, the new owner becomes strictly responsible for the eventual return of that deposit, minus any lawful deductions, regardless of whether the original landlord actually transferred the funds successfully.
When it's finally time for that deposit to be returned, banks will often try to withhold funds to prepare the foreclosed property for sale. However, the law strictly separates normal wear and tear from actual property damage. Faded paint, minor scuffs, and carpet thinning in high-traffic pathways, that's just everyday wear and tear, and it must be absorbed by the property owner. Banks can only make lawful itemized deductions for actual property damage, like deep gouges, unauthorized paint jobs, broken appliances, or neglected water damage.
Finally, we arrive at Part 5, Strategic Defense.
The most critical, urgent directive for any renter in this situation is so simple but so important. Do not vacate immediately. Tenants should never, ever self-evict based on a bank's informal request, a letter taped to the door, or a threatening phone call. The legal process requires formal written notice and strict adherence to federal timelines.
You'll frequently see banks attempt cash for keys offers to sidestep that 90-day federal requirement and clear the property quickly. While these financial settlements can definitely be highly beneficial, occupants absolutely must calculate the full cost of a forced move before signing away their statutory rights. Furthermore, maintaining hard documentation is the only way to prove a bona fide tenancy in court. This means meticulously documenting the original lease. It also means maintaining a flawless paper trail of all rent payments made before and during the entire foreclosure process.
So, what's the game plan? Here are the ultimate actionable steps that occupants must take to maintain their statutory leverage. First, check the exact terms and the expiration date of the lease. Second, verify PTFA status by ensuring that tenancy meets those bona fide requirements we discussed earlier. And finally, keep paying rent. Withholding rent during a foreclosure is an incredibly dangerous strategy that just hands the bank a legitimate, at-fault reason to initiate an eviction. Rent must be paid to the new entity on time.
At the end of the day, the foreclosure fallacy relies entirely on the occupant's lack of legal knowledge. Financial institutions literally bank on renters packing up and leaving without a fight. These laws exist to prevent sudden displacement, but they require the occupant to stand firm. So when a bank demands the keys, will the occupant just surrender their home without question, or will they enforce their federal right to stay? Understanding the federal shield is the very first step in ensuring that a change in property ownership does not result in an unlawful loss of housing.